On Monday, the Minister of State for Home Affairs, Ajay Mishra Teni, introduced the Criminal Procedure Identification Bill in Parliament. If passed, the new law will replace the existing Identification of Prisoners Act 1920. The existing act allows the police to only take the fingerprints, footprints and photographs of those who are arrested or convicted. These records are stored in the physical form. The new bill proposes to digitize criminal identification records. It also extends such rigorous identification procedures to include even those who are detained or picked up on suspicion. Iris and retina scans, photographs, finger impressions, palm print impressions, footprint impressions, physical and biological samples. All these are for the police to take. The scope of the bill even covers narco-analysis and brain mapping. It will further allow the police to collect the behavioral attributes of suspects, including signatures and handwriting samples. The National Crime Records Bureau will collect, store and preserve the records for sharing and dissemination. The records will be detained for no less than 75 years from the date of collection. Why does the government want to pass the bill?
जो पुराना अधिनियम मौजूदा है, जो इस समय प्रभावी है, वो 102 वर्ष पूर्व स्वतंत्रता से पहले 1920 में बनाया गया था और उसमें केवल फिंगरप्रिंट और फुटप्रिंट को लेने की ही सहमति उस अधिनियम के द्वारा दी गई थी। अभी दुनिया में बहुत सारे परिवर्तन आए हैं, टेक्नोलॉजी बढ़ी है, वैज्ञानिक प्रक्रियाएं बढ़ी हैं और पूरी दुनिया में जो अपराधियों को और अपराध करने का ट्रेंड बढ़ा है, उसके अनुसार इसको विस्तारित करने की आवश्यकता थी और इसीलिए दंड प्रक्रिया शनाख्त अधिनियम 2022 हम लेकर के आए हैं, जिसमें न केवल जो प्रक्रिया है मेजरमेंट की उसको विस्तार देने का काम किया गया है, उसके साथ साथ उसकी श्रेणियों में भी वृद्धि हो उसका भी हमने काम किया है। लेकिन ये छोटा अधिनियम है जिससे न केवल हमारी इन्वेस्टिगेशन एजेंसियों को फायदा होगा, प्रोसिक्यूशन बढ़ेगा और प्रोसिक्यूशन के साथ साथ कोर्ट में कन्विक्शन की प्रतिशत भी बढ़ने की पूरी संभावनाएं इस एक्ट के माध्यम से हमको प्राप्त होंगी।
Opposition MPs across parties have opposed the legislation, calling it a direct violation of the fundamental rights of individuals. They say the bill gives more than necessary powers to the investigating agencies.
This is the first step towards making India a police state. And the government, particularly by amending the CRPC sections, is going to make the process of the criminal justice system more complicated. We are maturing to come to the terms with the modern technologies, modern kind of CCTV cameras, all this kind of things by in which we are able to becoming little more towards technology-based criminal justice system. India like state can't give this much power to the policemen. All these kind of things which is illegal in nature can be done by this kind of with the support of the law itself.
The opposition has also raised concerns about data security. Suppose a person who's never been convicted before has his or her measurements taken and is again released without trial or is acquitted by the court. Under the new law, this person's records have to be deleted. However, given that digital data can never be fully erased, questions of privacy are being raised. The opposition is also concerned that those in power may misuse the provisions of the bill to legally target those who oppose the government.
This kind of amendments will enable those people who are in power to misuse it in a very big way, and it will more or less make India as a police state itself. Data privacy is still a question in Indian system, and therefore we feel that it is very, very dangerous for the system for these kind of amendments to be in practice in India.
The opposition has now united to demand that the bill be revised. It's confident that it can stop the bill in its tracks in the Rajya Sabha. What remains to be seen is whether the opposition can really pull it off. A Federal Report.